Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to another podcast. I think by now we're up to episode number 112. So let's see what we're talking about today. Hang on, that can't be right. It says we're here to talk about La La Land. No, obviously we're here to talk about three most recent cases in employment law. We have one case on the importance of running a correct appeal process in any internal disciplinary hearing. We've got a case on subject access compliance. And finally, an instructive case about an employer who thought it had settled all claims that could be brought by one of its employees, but had overlooked statutory maternity pay. I should also start with an apology. We've missed an episode, which I think is the first time that's happened in nearly 5 years, but we got caught up in a speedy trial which came in January and went all the way through to a hearing last week and the start of this week, and so that rather took over everyone's lives for certainly the last month. Anyway, as usual, you can access the podcast via iTunes. It's on the Mayor Brown website, YouTube, Twitter feed, Nicholas Robertson at NicholasRobber11. And that, of course, is where we put out the links to the cases too. So, without further ado, let's not talk about La La Land. Let's talk about Khan and Stripestar Limited. This is an EAT decision. It offers a very useful illustration about the importance of having a thorough appeal process in place, because the employer in this case was only able to defend an unfair dismissal claim because it had done such a thorough appeal. The background? Well, Mr. Khan was employed in a vehicle repair workshop. A customer brought a car in for repair, but decided the car just wasn't worth it financially to have the repair work done. Contrary to the company's rules, Mr. Khan bought the car directly from the individual. He then authorised his colleagues to work on the vehicle to repair it, but told them not to record the time. He had to compile a job card, however, recording what they were doing, and he filled the job card in, showing that the work was being done for the customer who had previously owned the car before Mr. Khan bought it. The employer found out and dismissed him, both for purchasing the car and for disguising the fact that he was having work done effectively for free on it. It seems the disciplinary hearing was very short and sharp. The disciplinary manager was Mr. Khan's line manager, a Mr. Abercrombie. It lasted all of 6 minutes, and the employee had no opportunity to make any representations or put forward his point of view. The employee appealed, and in retrospect you may think that's where the employee went wrong. Clearly at that point the employee had a slam-dunk unfair dismissal claim. The process was clearly unfair. He'd been allowed to make no representations during the hearing, and there'd been a very cursory hearing indeed. And there was a twist, which I'll explain in a second. At the second stage, the appeal stage, there was a thorough investigation into matters. Mr. McCallum, who was the appeal manager, interviewed the people at the workshop and Mr. Abercrombie. There was a suggestion from Mr. Khan that Mr. Abercrombie actually knew he'd purchased the car and turned a blind eye to it. Mr. Abercrombie, however, denied knowing of the purchase of the car. After the appeal hearing, Mr. Khan's dismissal was confirmed. So, he claims unfair dismissal. However, he failed in his claim, notwithstanding the extremely shoddy first disciplinary hearing in front of Mr. Abercrombie. The tribunal took the view the appeal process had been sufficiently thorough and fair that it remedied the unfairness of the initial decision. This was despite the fact that they thought that Mr. Abercrombie, who'd done the initial disciplinary hearing, probably was tainted himself, in that they found he probably was aware of the purchase of the car. The employee appealed against the tribunal's decision to the EAT and contended that the disciplining manager's bad faith, given that he was found to have known about the purchase of the car and didn't say anything during the disciplinary process, meant that the whole process was tainted and could not be saved by the appeal. The EAT, however, were not in agreement. The tribunal started off with the obvious test laid down in the BHS and Birchall case, that for a misconduct dismissal to be fair there needs to be a reasonable investigation on reasonable grounds and a genuine belief that the individual was guilty at the far end of it. The appeal manager's decision ticked all the boxes. There was clear evidence of gross misconduct. In support of the appeal to the EAT, Mr. Khan pointed out that if an employer issues a warning in bad faith, that leads to dismissal because that warning is subsequently relied on after another disciplinary incident arises, then that subsequent dismissal is not capable of being rectified by a thorough appeal during the disciplinary process leading to dismissal. Well, the EAT distinguished between that situation and the situation in the current case where the initial disciplinary hearing was potentially conducted in bad faith, but that hearing was not ultimately relied on in assessing whether dismissal was fair. It was the appeal hearing that by itself justified the dismissal. As a matter of logic, I think that's an entirely sensible approach. Clearly the statement by the EAT that there are no limitations on the nature and extent of deficiencies in the first stage disciplinary hearing that cannot be cured by thorough and effective appeal is very clear and helpful. And it's been the case for quite some time. We've known a well-conducted appeal and a thorough appeal can rectify any procedural shortcoming. But this is a particularly stark example. The disciplining manager in the first instance was found to be probably tainted in the view of the Employment Tribunal. Even this was a flaw that was capable of being rectified by having an untainted manager at the appeal stage conduct a thorough review. And the case is undoubtedly in line with tribunal orthodoxy. However, I do wonder if one day we might see a challenge to this thinking. Surely the point about having a disciplinary hearing and an appeal process is that both stages ought to be fair. An employee is entitled to 2 bites of the cherry. If an appeal process is permitted to rectify any note earlier flaws, then is the employee being treated badly or fairly? There would still be an incentive for an employer to conduct a thorough appeal, because it might convince the tribunal that compensation would be significantly reduced if there had been an irrevocable problem at the first instance. Anyway, that's one for another day, because the law at present is very clear. A well-conducted appeal is sufficient. Equally, if you're trying to persuade a senior manager to devote sufficient time and effort to hearing an appeal and engaging in it, this case could be a very useful example to give, because a good appeal can cure the flaws at the initial stage, and obviously a bad appeal can jeopardise the company's defence of any subsequent claim, even if the initial disciplinary hearing had been conducted perfectly. So, that's the case of Khan and Stripe Star Limited. Next up, Dawson Damer and others and Taylor Wessing LLP. Data subject access requests are undoubtedly on the rise. I haven't seen any statistics to back this up, but we are seeing many more of them in practice, and they're either being used either independently or alongside litigation. This case concerned a data subject access request served on a firm of solicitors who were involved with a trust dispute going on in the Bahamas. It was not an employment dispute. However, just to prove there was nothing new under the sun, we served a data subject access request on behalf of a client on a firm of lawyers acting on the other side of litigation probably 10 years ago. There were certain factors that made that desirable. So it's hardly a brand new tactic, but I think this case will rejuvenate that particular approach. I won't go into the facts in any great detail, other than to say that Taylor Wessing's client was a Bahamian trustee company. A dispute arose in the Bahamas between beneficiaries under the trust and the trust, and one party to that dispute served a data subject access request on Taylor Wessing, who were the solicitors, as I say, for the Bahamian trust company. Taylor Wessing said the client had complied with the request and that the material which they held was covered by professional legal privilege. The background, of course, is that the Data Protection Act 1998 gives individuals rights of access to their personal data. That is obtained by making a data subject access request. Under paragraph 10, schedule 7, the recipient of the DSAR, the data subject access request, DSAR does not have to disclose personal data if it's covered by legal professional privilege. If a party wishes to enforce the DSAR because it says the recipient has not provided all the personal data that it holds, then he or she makes an application under section 7.9 of the Data Protection Act to the High Court. When Taylor Wessing failed to comply with the relevant DSAR, the party who had made the request applied for a copy of the personal data held by it and a court order to compel compliance. This failed at the High Court stage, but the Court of Appeal agreed with the party claiming the right to access personal data apparently held by Taylor Wessing. The first point was to consider in this context what it meant to say that personal data was covered by the legal professional privilege exemption. Taylor Wessing's client was the trust company. From reading the case report, the relevant personal data was not obtainable in the Bahamas directly from the trustee company. The trustee company in the Bahamas had the benefit of a legal exemption, whereby it did not have to provide disclosure under any circumstances. So the claimants, in this case, came to England and filed the data subject access against the trustee company's English solicitors to get hold of information which they could not get directly from the trust company in the Bahamas. Accordingly, it was important to establish whether the legal professional privilege exemption, which was relied on by Taylor Westing, was legal professional privilege as laid down in England and Wales, or did it cover instead legal professional privilege in the Bahamas too, which in this case would offer a blanket exemption. The Court of Appeal decided that the relevant legal professional privilege had to mean relevant privilege according to the law of England and Wales. The relevant section Schedule 7, paragraph 10, provides, quote, "Personal data are exempt from the subject information provisions if the data consists of information in respect of which a claim to legal professional privilege could be maintained in legal proceedings." Court of Appeal took the view that it was necessary to work out what, quote, legal proceedings, unquote, were being referred to in the section. They took the view these were legal proceedings in any part of the United Kingdom, so this meant that the exemption is for information covered by legal professional privilege according to the law of, in this case, England and Wales. Pausing there, this is of course an invitation to forum shopping in an appropriate case. If the English courts will apply English laws on privilege to foreign disputes, there's an obvious sense in which serving a DSAR on a party in the UK to require them to go through a DSAR process is going to be a smart move. In many cases, law firm advisors located in England and Wales are only handling matters within England and Wales, so the point won't arise. But there are plenty of cases where there will be an international element to the dispute, and the dispute may be in one country, but it involves another jurisdiction, and the laws of professional privilege in the other jurisdiction might be more favourable to the parties seeking to assert privilege than the equivalent English laws. Certainly, if you're advising on an international dispute and you're based in England and Wales, but as here you're handling matters in, is this one, the Bahamas, it may be necessary to think quite carefully about what information you wish to hold. Obviously, too, this isn't restricted to law firms, or the legal professional privilege is of more relevance almost certainly, but this is a point generally, and ways to access, from holding companies, for example, information that may not be obtainable in the particular jurisdiction directly. Court also was faced with an assertion by Taylor Westing that providing copies of the document would involve disproportionate effort. Under Section 8.2 of the Act, the data controller's obligation is not an infinite one. It has to provide copies of information, and the legislation provides if the, quote, supply of such a copy is not possible or would involve disproportionate effort, unquote, then it doesn't need to be provided. And there's been a debate as to how to understand the disproportionate effort defence. The Information Commissioner has, for a considerable period of time, taken the view that the disproportionate effort test only applies to the process of actually supplying the information. In other words, the obligation to search is unlimited, and it does not matter if that search involves disproportionate effort. I'm pleased to say the Court of Appeal took a different view. They took the view that one of the central tenets of EU law is that proportionality should apply at all stages. Accordingly, the searches to be done by a data controller, in this case Taylor Westing, could be limited to those that did not involve disproportionate effort. The Court of Appeal expressly accepted that in appropriate circumstances there could be boundaries to a disclosure exercise. It's not an infinite process. The Court did comment, however, that most data controllers should be aware of their obligations, and so their data storage systems should be designed to bear in mind the need to recover all data efficiently. As a result of this, the Court of Appeal took the view that further compliance with the data subject access request had not been shown to involve Taylor Westing in disproportionate effort at this stage. So far, according to the case report, all it had done was review its files. Finally, there's been some debate as to whether you can fight off a DSAR if you could show that the request had a collateral purpose, namely using the material disclosed in litigation. Employers have often felt aggrieved about data subject access requests because they're an obligation to disclose personal data. It doesn't matter whether the data is relevant legally to the dispute or is indeed not particularly important. Conversely, DSAR can be a very powerful weapon in the context of the early stages of litigation, where it forces a party to go through a disclosure exercise often far earlier than it would normally do in simple litigation. There have been cases in the past where the courts have declined to enforce a DSAR on the ground that it was being made for a collateral purpose. Here, it seems highly likely that the DSAR was made for the purpose of using the material in the litigation in the Bahamas, but the Court of Appeal, however, accepted that a DSAR would be valid even if it was made for a collateral purpose of assisting litigation. So that particular line of defence seems to have gone. As I said at the start of this bit, the issue of the data subject access request is a thorny one for employers. There's a lot to be said for the Court of Appeal's approach that data controllers should bear in mind the likelihood of a DSAR arising and design data storage systems accordingly. However, all of this seems to overlook the fact that personal data is very rarely enshrined in a silo. Often it comes as part of a long list of similar information about colleagues or comments made about the person seeking the DSAR, and it's wrapped up with comments made about others working around them. What do you do about comments that are made by an individual about someone else, to the extent that that gives you personal information about the person making the comment? Personal data, the disclosure exercise is usually pretty time consuming, because you have to review other people's personal data, redact it, depersonalise it, and that's time consuming and challenging. The Court of Appeal case, to the extent that it offers guidance and clarifies the parties' obligations, is helpful, even if in at least a couple of areas employers might have wished the Court of Appeal had gone the other way. So that's Dawson Damer and others and Taylor Wessing LLP. Final case, Campus Living Villages UK Limited and the Commissioners for Her Majesty's Revenue and Customs and Joanne Sexton. This is a case from the First Tier Tax Tribunal on payment of statutory maternity pay. No, wait, come back, I promise, it's worth listening to. Miss Sexton Miss Sexton worked for Campus Living. A dispute arose whether she was entitled to statutory maternity pay of a bit over £42,000. There were several points at play in this case, but the one that I want to talk about relates to the terms of the settlement agreement which she had entered into. Facts? Well, Ms. Sexton started working for Campus Living back in 2010. She became pregnant and was due to give birth on the 28th of January 2015. However, her employment ended on the 26th of December 2014, allegedly on the grounds of redundancy. She claimed unfair dismissal and pregnancy discrimination, and the parties entered into a Cot 3 form to settle everything. I note in passing the settlement in the Cot 3 form was less than 2 weeks after she'd given birth, which I think we can agree is pretty impressive. The Cot 3 form provided that she was to get £60,000 in full and final settlement of all or any claims she had. The £60,000 was broken down as compensation for injury to feelings, £20,000, £30,000 tax-free, and the balance, £10,000, was to be taxed at the appropriate rate. The parties asserted they did not believe that any national insurance payments were due. That's relevant, I'll come back to that. In the normal way, the Cot 3 form listed various statutes and claims arising under them being compromised, but said that the list was not limited to those, the list of things being settled, was not limited to those particular statutes, because as I mentioned already, Clause 1 said it settled all and any claims. Moreover, during the negotiations leading up to the settlement, Ms. Sexton had claimed a total of nearly £100,000, including £41,000 in round terms, in respect of maternity pay entitlement. Her particular calculation was debatable because it was based on annual salary rather than an SMP calculation, but there had been a claim put forward. So, what could go wrong? Full and final settlement clause, Cot 3 form, she gets £60,000 having claimed £40,000 for maternity pay. She can't possibly be entitled to SMP of an additional £40-something thousand, can she? Oh yes, she can. First of all, the tribunal pointed out that a woman cannot contract out of her right to receive SMP. Any such agreement is void. There was no evidence that the settlement payment actually included Miss Sexton's entitlement to SMP. And in this case, it was relevant that no national insurance contributions were made, but which it would have been necessary to make payments of national insurance contributions if SMP had been paid to her. SMP attracts national insurance contributions. Therefore, Campus Living was found not to have paid out her entitlement to SMP, and she was therefore entitled to SMP on top of the sum in the COT3 form. One imagines that the tribunal decision would not have been greeted with rapturous applause by Campus Living. Fairly obviously, having paid out £60,000 in respect of a claim of just under £100,000, they would have understood they were taking care of all claims, as it said in the agreement. It clearly would have been open here to have specified that part of the £60,000 was the entitlement to SMP. However, they didn't do that for whatever reason. It could be that the desire to save national insurance contributions on the severance payment instead of paying it on SMP proved to be their downfall. However, this is a really useful case to be aware of. Parties may not be aware that you cannot contract out of your entitlement to receive SMP. The only way of covering it in a settlement agreement is to pay it expressly in the settlement. If a woman is being dismissed after she has qualified for SMP, this is a point that is either needs to be addressed in the agreement, or at the very least the employer needs to know that it is in for a further payment. So, that's the case of Campus Living Villages UK Limited and the Commissioners for Her Majesty's Revenue Customs and Joanne Sexton. So, that's all. Thank you very much indeed for listening, as always. I think in time-honoured fashion, it only remains for me to confirm that at no point during the making of this podcast was Article 50 triggered. Thank you very much indeed. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.